Hello and welcome to Law Weekly on Channels Television. I'm Victoria Idowu. Today on the program, we will bring you the second part of the interview conducted by my colleague Solanke with renowned Nigerian lawyer and administrator Solanke. On the second part of the program, lawyers discuss on how the COVID-19 has affected them and also the rights of citizens during this period. Welcome to the program. Born in 1932, Solanke is Nigeria's first female senior advocate of Nigeria and the first Nigerian female lawyer to wear the silk gown as senior counsel. She is the first commissioner of Western State and is a former chairperson of the Western Nigerian Television Broadcasting Corporation. Wow, that's a lot of first. A woman of great accomplishment in the legal profession, she has inspired other women greatly. Aside from being the legal giant, she is a teacher and a public administrator of note. My colleague Solanke spoke to her on a number of issues, one of which is how to handle challenges within the legal profession.
I hear you talk, Ma, about the role of the Nigerian Bar.
Yes.
Amongst other, the roles of the media and other professionals. Yes. And there are those who say that the Nigerian Bar Association is supposed to be the voice of the voices, but that they're not doing enough. That lately it seems like the bar has lost its voice. What do you think?
Well, it grieves my soul that you are expressing what the people are saying. And Nigeria, the situation is so complex. And the Nigerian Bar Association, as you know, is made up of all of us. We are statutory members. So it depends on the leadership. And the leadership needs to be more vocal and to really be heard to be the voice of the people. It's not possible for me to sit and condemn my own association. But all I can tell you is that whenever I have an opportunity, I do speak up. And we continue to engage in self-assessment, self-awareness about what we are doing. Certainly the Nigerian Bar Association, we should do more. And we will continue to try to do more.
Let's talk, Ma, now about issues of the profession. I want to talk about issues of discipline and integrity among lawyers and judges. It's a big issue. We've seen some judges, some senior advocates being held in on corruption charges, money laundering charges. It's almost endless. And people are wondering, this is supposed to be the place where the common man runs to. It's supposed to be the last hope of the common man, as people say it. And now it's the judiciary that's on trial. Every day people are condemning. So much so that even when judgments come out, people don't know whether the judiciary has been tainted or corrupted in giving some of those judgments. It's that bad. How do you think, Ma, that we got to this stage? What happened? What do you think happened?
Let me start with the judiciary, because that's the apex of the legal system in the country. When I joined this learned profession, now that was 1963, 56 years plus now, there was no whisper or allegation or suggestion of corruption. But gradually, in the last maybe about 3 decades ago, few accusations, magistrate level. Then about 2 decades ago, few accusations about the High Court. And then about maybe a decade ago again, Court of Appeal, Supreme Court. It's really something that grieves my soul that anybody could be speaking about judicial corruption anywhere. Anywhere now they talk about it. And in all my lectures, I always say that not all judges are corrupt. There are some of them who labor night and day to give of their best and to make sure that judgments are based on evidence received and the applicable laws. At the time when I joined, judges of the High Court were invited to come to the bench. Sitting judges would have observed them, know about their reputation, observe them in the courtroom, and they would have advised them to come and join the bench. I was invited to come and join the bench in Lagos State because my father, J.S. Odolate of Alabukun fame, was from Lagos. My mother was from Abeokuta. I had invitation to come to the High Court. I had invitation to come to the High Court in Ibadan, Oyo State. But I'm so enamored of advocacy.
You didn't take up any of those offers?
No. And in 1987, I was actually invited to come to the Court of Appeal. So, but in giving it serious consideration, I just felt that I didn't have what I told Justice Nasser, he was the Court of Appeal president then, and Justice Bello. I had to go and see them when they offered it to me. I had to go and see them in Lagos. To say I didn't have the divine push, that was how I put it, to leave advocacy.
For the bench.
And go to the bench. So Justice Bello said, having put it like that, divine push, they cannot say anymore. So I think we should stop applications for judgeship. That's what's going on now. And it should not be based on who your father is, or who your mother is, or where you come from. It should be purely knowledge and merit. We shouldn't. So there's a lot of problem in the appointment of judges. You do from the High Court, they go to the Court of Appeal, they go to the Supreme Court. Many are good, but many are giving us concern.
But on the issue of constitutional amendment, there are those who argue that we need constitutional reforms. There's those who say that it was a military document. We need a new constitution altogether. What do you think?
There are many areas of the Constitution. Let me focus on the judicial reform. Now, many cases, many appeals, we should never reach the door of the Supreme Court are there. I mean, somebody has a case where some goats were killed or something, and that got to the Supreme Court. Tenancy agreements, you know, matters like that should never get to the Supreme Court. And it is important for the Supreme Court itself to engage in self-criticism, self-awareness, self-assessment, to address the loss of confidence of the people in the Supreme Court. That is where our salvation lies. The Supreme Court is there to make sure this country is as it should be. So if anything goes wrong with the Supreme Court, we are in trouble. If anything goes wrong with the court, we are in trouble. I mean, look at the way the former Chief Justice of Nigeria, Onnoghen, the Honorable Justice Onnoghen, was removed. I'm not advocating for anybody, for any wrongdoing. No. I'm advocating serious breach of due process. The Chief Justice of Nigeria was removed on a nocturnal order of a tribunal. The National Judicial Commission never even was involved. this, I mean, by the time it got involved, it was too late. I still cannot get over it, that the CJN was removed.
In such questionable circumstances.
Nocturnal order of a tribunal. That is something that history is going to condemn, and it's going to be something that we must make sure doesn't happen again. Then, let me just say another thing that is causing trouble. The law enforcement agencies, I don't know, some of them regard lawyers as their enemies. We must have an easy relationship between the lawyers and the, law enforcement agencies. But for policemen or whoever to break into a federal high court to remove Sowore, I mean, that's an assault, the greatest assault I've heard of on the rule of law. That somebody was in the very bowels of the court. Somebody was being seized who had just been released by the court. What has happened to those who perpetrated that, those who did it, what has happened to them? I don't know. Did anything happen to them? I don't know. So we must return to respect for the rule of law.
I want us to talk about the standard of legal education. Are you part of those who think that standards are falling?
Indeed.
And what can we do to lift the standards?
Yeah. All right. I'm taking it from the beginning. Right from the primary school to secondary school to university, standard has fallen. Then, when they get into the university, whatever remedial action the university can take, at least to improve the level of education they've brought to the university. And the law school, the curriculum belongs to the last century. We are now in the 21st century. That curriculum belongs to the last century. That is where you really want to do a lot of work to make sure that the curriculum is re-examined and updated to deal with globalization, IT, information technology. I don't think they have a technology course in the law school. They should have it. I hope some of the universities have it. But the law school, because legal practice has become globalized. And I advocate lawyers without borders, and like doctors without borders, so that you can practice anywhere in the world. So, more importantly, the curriculum in the law school must be updated, must be upgraded. And infrastructure. The problem in the courts, including the Supreme Court, lack of sufficient infrastructure, so that even when they have more judges, they have appointed some, but they are waiting confirmation at the Senate. So they need to make sure that infrastructure is improved. Less writing for the judges. I read that the website that was established for the Supreme Court
has become obsolete.
went off, is out of function now. That's one of the areas that the Supreme Court itself must engage in self-assessment. It's their website. The Supreme Court is responsible to ensure that the website is functioning. I know that the Director General is trying his best. Infrastructure is inadequate. Those who have children there have to put them in hotels. Hotels near, people have people are making money out of it. They know that the hostels for students are poor, no water, no light, no that. So there are now hotels where those who can afford it, but not everybody can afford it. So infrastructure must be improved for the law school. Infrastructure must be improved for the courts.